In 2013, the Philippine administration brought an arbitration case over the South China Sea dispute with China, prompting a 5-member arbitral tribunal. In 2016, the tribunal issued a so-called final award denying China's long-standing historic rights in the South China Sea. The Chinese government immediately declared the award null and void. China neither accepts nor recognizes it.
In 2006, China made an exclusionary declaration under Article 298 of the United Nations Convention on the Law of the Sea. It states that China does not accept any of the compulsory settlement procedures provided for in the convention with respect to disputes concerning maritime delimitation, among others. And the South China Sea Arbitration Tribunal ignored China's declaration and forcibly exercised this jurisdiction. We can also see that the arbitration tribunal has made a lot of jokes. For example, in interpreting Article 121 regarding the definition and judgment of islands, the tribunal completely deviates from the national practice of the entire world and the international community. Former president of the International Court of Justice, French Judge Gilbert Guillaume, once said that the arbitral tribunal was simply rewriting the relevant provisions of the convention.
The very formation of the tribunal has also raised a lot of doubts.
5 judges are composed entirely of European judges. A judge comes from Ghana, an African country, but he has lived in England for a long time, so can be regarded as an European. The others are from France, Germany, the Netherlands, and Poland. They have no understanding of Asian affairs and the South China Sea issue. The South China Sea issue is not a simple maritime dispute issue, so it is unrealistic that you can solve it with just a few arbitrators. In November 2015 in Ottawa, I asked Junji Yunagi a question. I said China and Japan have territorial disputes and asked the president of International Tribunal of the Law of the Sea of Japanese nationality, you should rescue yourself from the appointment of arbitrators in the South China Sea arbitration case. He avoided my entire question and did not answer.
Following the tribunal's decision, the Chinese Foreign Ministry released a statement. It said the Philippines violated its standing agreement with China to settle their disputes through bilateral negotiation. It also violated China's right to decide its own means of settling a dispute as a state party to the UN Convention on the Law of the Sea.
The South China Sea Arbitration Award as an award cannot be a part of international law in itself. A politically manipulated, erroneous, and biased arbitration award, if made a part of international law, will have an indelible negative impact on the integrity, authority, and fairness of the international rule of law.
China has also made it clear that no political manipulation disguised as legal moves will go anywhere or deter China from safeguarding its territorial sovereignty and maritime rights and interests.